frustrating you.
So I am not frustrated. I'm frustrated by your failure to
I'm not a failure.
permit the court to proceed with how it has to proceed. I just explained to you why I can't do it the way you want me to do it.
Because he submitted an answer. Is that correct?
What did I just tell you, Miss Norman? What did I just tell you?
Sir, I've been in this courtroom almost probably 13 times now. It's very frustrating for me. I'm not a failure. I'm doing everything that I can to end this court case.
Norman, I'm going to tell you this, and then I'm not hearing anything else from you. I'm going to do what I'm going to do.
That's fine.
I'm just going to, no, do not talk. Stop.
I said I won't say anything else.
Stop. Just stop.
That's how you treated me in October of 2024 as well.
I'm done. Then here's what we're going to do. We're not sending it. She'll wait for the mail. I'll just adjourn this case out. Where are we adjourning it? Yep. We'll just put it out so she can get the mail. I'm going to do it that way. I was trying to expedite it for her, but she's going to treat me rudely. It's not going to happen that way. Rudely. Give me a date. Respectful. I'm done. Mute her because I'm done with you.
March 10th.
March 10th. I'm adjourning this to March 10th, 2026, 9 a.m. Thank you. You can kick her out.
All right, guys, buckle up because this courtroom hearing completely spirals out of control in just seconds. What starts as frustration over delays quickly turns into a direct clash between the defendant and the judge. You can literally feel the tension building as the judge tries to keep control while the defendant keeps pushing back emotionally. Then comes the moment that changes the entire atmosphere of the courtroom. The judge finally loses patience, orders her muted, and shuts the hearing down completely. This is one of those rare courtroom moments where everything snaps at once.
I'm sorry,
your names?
Asim Yassin.
Iris Yassin.
All right. Morning. Oh boy, here we go.
Good morning, Your Honor. I'm Justin Yu. This is my partner, Lazar Georgia. We asked this court permission to appear on behalf of our clients, Mr. Underbill and Mr. Jackson, under MCR 8.120 and under the supervision of David Santacroce.
I don't know. Where are you from?
From Seattle.
Seattle. Did I ask that of you? I may have. You've been before me before, right?
First time.
Yeah. Today's the first time?
Yes, sir.
Yeah. You're from Seattle?
Yes, Your Honor.
It's really damp there.
Yes.
Congratulations on your Seahawks.
I'm actually a Patriots fan, Your Honor.
You are?
Yeah.
I hate you. Because I am not. The only reason I was rooting for the Seahawks, it was ABTP, anybody but the Patriots. I don't like the...
All right, guys. Before this case turns serious, the courtroom unexpectedly turns into a comedy show. The judge immediately starts joking with the attorneys about football teams, hometowns, and rival cities, creating one of the most entertaining openings you'll ever see in a legal hearing. But underneath the humor, you can already see the judge, sizing everyone up, testing personalities, and controlling the room. The playful back and forth may sound harmless, but it actually sets the tone for how sharply this judge handles people once the real legal pressure begins later in the case.
What?
That was a terrible answer.
It was horrible. Horrible. Why are you a Patriots fan?
I was born in Boston, Your Honor.
Oh, well, that's a problem. Okay. So where'd you go to undergrad?
Tufts University in Boston, Your Honor.
In Boston. And then your family's in Seattle.
Yep.
So you came back to Boston and now you're at Michigan.
Yes, sir.
You just can't figure out where you want to be.
Right.
Okay. And what about you?
Yes, Your Honor. I'm from Chicago.
Yay, Midwestern.
Yes, sir.
I love it. Born and bred? Or?
I was born in Bulgaria. I moved to Chicago when I was very young with my family.
Bulgaria. Where'd you go to undergrad?
I went to Northwestern in Evanston.
Okay. I have a a niece out in Chicago at Loyola. So
Very good.
I'll take it easy on you. So when it gets tough, turn it over to him because I like him better than you being a Patriots fan. All right. All right. Thank you, gentlemen. Permission to practice is granted.
Thank you, Your Honor.
All right. And where are we on this case?
Your Honor, I was served yesterday after I saw the email at 8 o'clock at night where they have a counterclaim, so I would like to motion to get a continuance in order for me to be able
To answer the counterclaims?
Yes,
All right.
according to the statute, whatever the court deems
All
appropriate.
right. How much time is it going to take for you to answer the counterclaims?
Well, to answer the counter, between 21 and 28 days is what I would like in order to be able to get out the,
No, I probably won't give you quite all that time, but okay.
I'm
I
sorry.
probably won't give you that long.
Okay,
to
but
file an
the-
answer.
The court deems appropriate, but you know, I will try to do my best.
All right. All right.
Your Honor, we'd agree to a month because we have some additional discovery to conduct. We just received this case last week and we don't have all the
Students
documents.
are so cute. We'll agree to a month because we don't care about the court schedule.
This is where the actual legal conflict starts taking shape. One side reveals they were hit with a late-night counterclaim and immediately asks the court for more time, while the defense pushes for additional discovery and repair records connected to the property. The conversation suddenly shifts from jokes to serious procedural issues, especially when repairs, plumbing problems, and missing documentation enter the discussion. The judge steps in hard here, making it clear that both parties are expected to cooperate fully or risk creating bigger problems later in the lawsuit.
We just got to go to class. No, go ahead. I'm sorry. Don't mean
We
to
just
interrupt.
had this case last week, Your Honor, so we don't have all the documents yet, and we discussed with plaintiffs that we would ask for maybe a ledger or any communications or documents relating to any repairs that will be an issue in this case. And this will also give us time to file any FOIA requests to get inspection reports from the city, Your Honor.
So do you have a problem with the month adjournment?
No, Your Honor. That's cool. There's no-
Nobody cares about my docket. Nobody cares.
Or, you know,
No, I know. You're saying whatever. They don't do that. They come in just like demanding a month, but they get that from Santa Croce. Just demanding time. All right, let's do it this way. Do you have a ledger that you can provide them and repair records?
I will provide them with whatever I have, I will provide it to them. Yes, I do have a ledger.
Okay,
I have payment ledgers, I have, you know.
okay, but what about documents regarding repairs to the
I will
premise?
have to look them up because there has never been any repairs except for one time, 2-3 years ago, when there was a little water problem. And I had to pay a plumbing company to come and clean up the
line.
line. They did that, and after that, everything has been good. And besides that, repairs, changing of smoke detectors. It's been basically because it's
Okay.
construction and it doesn't need a lot of repairs. Oh, we did change the roof 2 years ago. That was but that was preempted.
So you're going to be able to provide that ledger to them, say, within the next
Yeah, I
week?
will provide them with everything that they asked me for.
Okay,
And I will also be asking them to provide for a lot of proof because they have a lot of allegations that are out of the air. I'm sorry if I'm talking too much wrong.
all right. No, that's okay. So, well, here's what this is the way the court works without necessarily issuing a formal order for discovery. I expect the parties to cooperate with each other regarding the information. So if you ask them for something, to the extent that it can provide it, if it's there, the obligation is there for you to provide that. Same applies to you.
Yes.
All right, everybody's understood regarding that? All right. So what I will do then is I will indicate that you're to answer the counterclaims. In this case, you're to do that by February 24th. I'm going to give you 2 weeks to get an answer in on that.
Okay.
Okay?
Your Honor, one question, please.
Yes, sir.
I need them to provide their address because I heard that the address that they gave is not their address, but it's
You need to provide who?
the
Tenants?
the defendants to provide their correct address so that notifications can be made correct.
In terms of the,
Whatever address they want to provide to be notified to.
you mean in terms of your answer?
Yes,
Your answer should be sent to their attorneys. You shouldn't be sending things directly to the defendants.
so we do not need to have their address or anything on record.
Well, why do you need their address at this point?
Okay, the first thing that I was going to do was to send them, which I already probably provided them. They need to provide the address when they move 5 days after they move in order for us to be able to provide them with whatever.
Oh, 4 days, but yeah, go ahead.
And we haven't had that yet from them. So that would, I would, in case anything like that needs to happen. And, but otherwise I would just,
Well, hold on a second. At this point, you're seeking to provide them something.
no, I already did the last time.
Okay, hold it. I'm trying to figure out, why do you need their address right now?
Simply because the law says that I need to have.
They were supposed to supply to you a forwarding address within 4 days of the date of vacating the premises. And their failure to do so has its ramifications if that becomes something involved in this case.
Now the hearing starts getting complicated. What begins as a simple argument over a forwarding address suddenly evolves into a much larger legal issue involving corporate ownership, subleasing, and possible loopholes. The defense questions whether the plaintiffs are improperly using a corporation to avoid legal requirements, and even the judge admits the structure looks unusual. You can hear the courtroom slowly realizing this may not be a standard landlord-tenant dispute anymore. At this point, the discussion moves beyond paperwork and starts touching real liability concerns that could seriously impact the entire case.
Okay.
So you don't need it. Any communication that you're going to have or make to the defendants in this case, you need to go through their attorneys.
No problem. Your Honor.
All right. So you're to answer by February 24th.
I will.
All right. And then I will adjourn this matter to March 10th, 2026, 9 a.m.
We have one more issue to raise.
Of course you do. Why? Because they're from Michigan. There's always going to be an issue. Go ahead.
Right before this hearing, that the property in question is owned by a corporation that plaintiffs own. They own the corporation, which then leases the property to plaintiffs, which plaintiffs then lease to our clients. And under law, they can't represent a corporation. So we're just unclear on the law specifically here. But we just want to raise that to the court.
Well, who is the lease with?
The lease is with plaintiffs. They're just leased from their corporation.
So well, why would they have to have an attorney and couldn't represent things? Because
They can't represent a corporation if they're not a licensed attorney.
but are they representing the corporation? You're indicating that the corporation leased to them. And
Right.
so,
But the corporation owns the property, so the prior order giving them possession of the property would be to the corporation.
why wouldn't I treat them the same as I would that this really is a sublease? So
You're right.
if I treat it as a sublease, why would they have to get an attorney?
We don't have a clear answer on the law at this moment. We just wanted to raise because it does add some complications or possible complications to this case, Your Honor.
Your Honor, if I may,
Yes, sir.
it seems like a perpetual, it's a wholly owned LLC. And in order to avoid having to retain counsel to represent that LLC, it's some sort of perpetual sublease to themselves individually. And then they lease it. Just, it seems clever at the very least. But I don't know, I mean, it obviates the rule that if you own a piece of property in a corporation and you benefit from owning a corporation, you have to hire an attorney.
Well, except that, I mean, you're right in terms of what you just stated about an LLC and the benefits that an LLC gets. The difficulty is in doing it this way, and the danger for them, while maybe clever in doing it this way, is that any liability is going to attach to them personally. And so that may be a problem.
For tax purposes, LLC doesn't have its own tax return. It's part of the individual return. So the legal identity seems the same. I mean, like they've been great, but we always prefer to have counsel on the other side. But we just I've never seen that before, so I just wanted.
I haven't either, and it's probably because the liability issues are probably potentially going to be substantial, and you're probably doing it this way. Frankly, they're going to lose the protection that the LLC has, but that may be their business. Yes, sir.
It's not an LLC, it's an incorporation. It's a C corporation. I live in the apartment where the lady lived. Where she.
Yeah, but sir, here's what okay, you talk over.
I'm sorry.
Go for it.
I'm sorry.
Here's what the issue is.
This section may sound calm at first, but it's actually one of the most dangerous moments in the entire hearing. The judge openly warns that if the corporation behind the property is nothing more than a shell or sham entity, the legal protection normally provided by that corporation could disappear completely. That means personal liability could suddenly become a major problem. The judge carefully avoids making a final ruling, but his warning is crystal clear. Get legal advice immediately because this structure could backfire badly if the case moves in the wrong direction.
And I don't know that I'm going to necessarily address it today. They've raised it as a potential. Is that it doesn't matter what type of corporate entity owns the premises. That corporation has leased to you.
Yes.
Okay. I think you need to understand that should they prevail on some issues, the liability for some of this goes directly to you. The corporation is not a protection from it. There may also be issues, and maybe this is what they're getting at. There may also be issues of if it is a circumstance where the corporation isn't really there, that it's just there in name, but you guys are operating, then they're going to go behind that corporation if they needed to get at the property. So
I understand that.
okay.
Corporation is legal, everything is up to date. And
Yeah, but so let me put it this way, and I'm not saying that it is, but if it were a situation that the corporate entity is really nothing more than a sham, that can create other problems for you.
I understand, Your Honor. But
Well, I hope you do. I don't know if we'll get there. Pardon?
It's an interpreting corporation which owns the premises, and it works with the courts. I provide interpretation for the court. I'm a qualified interpreter, so the corporation is good, Your Honor. So I have no wrongs.
Well, it may be for some purposes and maybe not for others. Yeah, I'm gonna suggest to you, sir, this having been raised, because I don't think you understand what I'm saying. I'm being very careful in what I say, that you may want to get some legal advice, because I can see where it may potentially cause some problems. Anything else?
That's it, Your Honor.
You sure?
Yeah.
You sure, Seattle?
Yes, sir, Your Honor.
He's a Patriot fan. He's a Patriot. You know what? I should take him. I should have you take him in. See? No. He didn't know what to do. He's like, oh my God.
One more question, Your Honor.
Yes.
You gave me 14 days, but could you give me 21 since they are asking for a month? That way I can have a little more time to provide them with whatever they are asking me to get.
I need an answer by then. I'm not saying that I need all of the documents.
Oh, okay, I'm answering.
I mean,
Even purpose to, if anything comes up, I can add it to the answer. Is that correct, Your Honor?
I'm not going to say it that way. You need to answer their counterclaims by that point. The providing of documents and other information between the parties is something that is going to continue throughout. So you get the 2 weeks. You can provide an answer to this in 2 weeks. I'll see you guys in 30 days.
Okay, Your Honor.
Thank you, Your Honor.
Thank you.
Thank you.
Have him write it in Bulgarian. Just what? Just see if he can, because I don't know if he's telling me the truth. I just don't know. Just saying.
I'm impressed. I didn't realize you read Bulgarian.
I do. I'm fluent. Yeah. That's easy. Thank you, guys. Take care. Stanford versus Norman.
Good morning.
Gil Stanford.
All right. Ms. Norman, can you state your name?
Susie Norman.
Okay. And that's a wrong screen. No, it's okay. I'm good. I'm good. All right. Where are we on this case, folks?
At the last hearing, we were reading on the evidences I sent. One was a flash drive.
Yes.
Due to the weather and the courts being closed, it hadn't been logged yet.
Correct. I think
also,
we have it now.
Yes. And I believe that your coordinator helped Mr. Stanford to play his flash drive.
Right. Did you get all the stuff off of the flash drive?
I did see the video of the previous hearing on that, yes.
Okay. And so with reference to that previous hearing, you have something you're holding up. What are you trying to do?
I submitted to the court an answer to that, and I sent a copy to her. I don't know if she's received it or not yet.
Is that the response to defendant's objections and evidence submitted about January 15th, 2024 hearing? That's what you, okay.
That's right.
All right. Have you received that?
I have not.
Okay, folks. All right. All right. Somewhere along the line, we've got to make sure, because it becomes impossible for me to conduct a hearing where one party has submitted something and the other party doesn't have it. And I'm not saying, I'm not blaming either party. I'm just saying that's the cold-hearted reality of where I end up.
Your Honor, may I say
How did you send this to Miss Norman?
U.S. mail.
Okay, well,
You know, and
that's gonna be.
I thought our hearing was a little later in the month. I thought she was gonna get it. And I just got the notice about our hearing date yesterday. So I was thinking maybe I should.
Well, that maybe should tell you something about the mail. All right, here's what I'm gonna do. I think we have Miss Norman's email, right?
Yes, sir.
Okay. So
Judge
folks are
Simpson,
not sure that, yes,
can I
ma'am.
say something, please?
Yes, go ahead.
That video from the hearing from 10/22 of 2024 has on there where Mr. Stanford waived his right to monetary damage and rent because of
Right.
the case, and my case being I dismissed my case in order to come to that end. So I don't know. I just feel like at this point we're just on the court's time and we're wasting it with
Well,
all of these things.
Ms.
It's just,
Norman, I understand what your position may be. My position is that if somebody submits something to the court, I have to at least look at it and consider it. The very fact, I don't think, if you think about the last hearing, you submitted something and I didn't get it because of whatever the circumstances were. I didn't have it. I don't think you would want me to proceed without having that. Mr. Stanford has submitted something. I'm not going to have a problem going through it. You just have to have it so that you can respond to it if necessary, because you're entitled to have it. Here's what I'm going to do. At this point, there'll be no additional filings. All right, because I don't want to end up in this circumstance. We have Ms. Norman's email.
Yes, sir.
All right. So what I'm going to do to expedite the process, Ms. Norman, because normally I'd put it out however long it may take the mail to get there. I'm going to have my staff copy what Mr. Stanford has submitted, email it to you so that you have it. Okay? And then
so what
my
happens
next-
then? He's got an answer to the video, and then I see something on his answer, but yet I can't answer.
Then you guys can argue that before me. Miss Norman, I can't force this to go any different.
I don't
If
want
I
to argue.
could-
I want it to end. I want it to end. And this is just how we were in October of 2024. Frustrating you.
So I am not frustrated. I'm frustrated by your failure to
I'm not a failure.
permit the court to
I'm not a
proceed
failure.
with how it has to proceed. I just explained to you why I can't do it the way you want me to do it.
Because he submitted an answer. Is that correct?
What did I just tell you, Miss Norman? What did I just tell you?
Sir, I've been in this courtroom almost probably 13 times now. It's very frustrating for me. I'm not a failure. I'm doing everything that I can to end this court case.
Miss
He has-
Norman, I'm
I'm
going to
just-
tell you this, and then I'm not hearing anything else from you. I'm going to do what I'm going to do.
That's fine.
I'm just
That's
going to,
fine.
no, do not talk. Stop.
I said I won't say
Just
anything else.
stop. Just stop.
That's how you treated me in October of 2024 as well.
I'm done. Then here's what we're going to do. We're not sending it. She'll wait for the mail. I'll just adjourn this case out. Where are we adjourning it? Yep, we'll just put it out so she can get the mail. I'm going to do it that way. I was trying to expedite it for her, but she's going to treat me rudely. It's not going to happen that way.
Rudely.
Give
I'm
me a
very
date. I'm
respectful.
done. Mute her because I'm done with you.
March 10th.
March 10th. I'm adjourning this to March 10th, 2026, 9 a.m. Thank you. You can kick her out.
Thank you. See you then.
Yep.
Everything finally explodes here. A dispute over missing evidence, mailed documents, and delayed filing slowly turns emotional as the defendant accuses the process of dragging on endlessly. The judge tries multiple times to explain why the court has to follow procedure, but frustration keeps boiling over until the hearing completely breaks down. Once the interruptions continue, the judge abruptly shuts the conversation down, orders the defendant muted, and adjourns the case. Moments like this are exactly why courtroom videos go viral online. If you enjoyed this breakdown, make sure to like the video, subscribe to the channel, and we'll see you in the next video.